we'll do is introduce ourselves, ask you to introduce yourself, and then we'll get ready. Okay? So my name is Beth Bratway. I work at the American Institutes for Research. I'm a Senior Technical Assistance Coordinator. Sue?
Sue Leeson, Senior Justice, Oregon Supreme Court.
John?
Sorry, I keep forgetting it mutes. I'm John DeLoach. I am the Senior Staff Attorney for the South Carolina Association of Counties.
Thank you. You can introduce yourselves.
Hi, my name is Luke Sherrill, and my favorite founding father is Patrick Henry for his defense of individual liberties.
Hello, my name is Caitlin Thorpe, and my favorite founding father is George Washington for his strong leadership and his willingness to lead a country right from the start.
Hi, my name is Sophia Adams, and my favorite founding father is Alexander Hamilton for his contributions to the ratification of the Constitution through his writings in the Federalist Papers. On behalf of Tahoma High School, our advisor, Gretchen Wolfing, and the state of Washington, we thank you for judging us today.
Thank you. We look forward to the conversation. We'll be discussing question 1 this afternoon. What were the major disagreements among the 55 delegates during the Constitutional Convention in Philadelphia, and how were they resolved? What issues, if any, were not resolved, and what were the consequences? What changes, if any, should be made to the Constitution? You may begin.
To suppose that any form of government will secure liberty or happiness without any virtue in the people is a chimerical idea. James Madison.
Issues regarding representation were among the largest disagreements that the delegates of the Philadelphia Convention were forced to resolve. While transitioning away from the Articles of Confederation, states were left to face an impasse between delegations from large and small states over how to apportion representation in the national legislature. Proposed resolutions included James Madison's Virginia Plan, arguing for a bicameral legislature with proportional representation.
Directly opposed was the New Jersey Plan, drafted by William Patterson, introducing a unicameral Congress with equal representation. After extensive debate, the delegates eventually adopted the Great Compromise, establishing proportional representation in the House of Representatives under Article 1, Section 2, and equal representation in the Senate under Article 1, Section 3.
This was a conclusion Madison later supported in Federalist 62. The government ought to be founded on a mixture of the principles of proportional and equal representation. With the House of Representatives set to be based on state population, slave states proposed that every enslaved person be counted as part of their population.
Future Vice President Eldridge Gerry opposed such an idea, asking, why should the blacks, who are property in the South, be in rule of representation more than the cattle and the horses of the North?
This debate was ultimately solved with the establishment of Article 1, Section 2, Clause 3, the Three-Fifths Compromise.
The issue of citizenship remained unresolved at the convention, creating unforeseen consequences that continue to affect the United States post-ratification. Even though Article 2, Section 1, Clause 5 mentions citizens, an explicit definition is never given in the body of the Constitution.
In Dred Scott v. Stanford, 1857, Dred Scott, an enslaved man, followed his owner to the free states of Illinois and Louisiana. Scott's owner argued that under Article 3, Section 2, Clause 1, African Americans were not citizens of the United States, and without a clear definition of citizenship, Scott did not have a viable case.
Without clearly defining a citizen, the ability to protect individual rights is limited. Anti-Federalists advocated for the explicit protections for individual rights. However, those rights did not extend to all living on American soil.
Slave codes were introduced to outline what rights were granted to those who were not citizens.
On December 6, 1865, slavery was officially abolished by the ratification of the 13th Amendment, which also meant the end of slave codes.
However, in 1877, Jim Crow laws were established which legalized segregation towards African Americans.
The perpetuation of this battle for equality has continued due to the lack of explicit definitions of citizenship and rights in the Constitution.
Amendments regarding the Electoral College and advancements of privacy would strengthen the Constitution.
To better represent the people of the United States, an amendment to the Electoral College found in Article 2, Section 1, Clause 3 is necessary.
Options such as the congressional district method, ranked choice voting, or a complete migration to a direct election would all aid in a more representative outcome for the American people in federal elections.
Aside from federal elections, privacy is never explicitly mentioned within the body of the Constitution and was only addressed with the addition of the Bill of Rights and judicial interpretations of Griswold v. Connecticut, 1965.
With advancements in technology, the Constitution needs an amendment protecting citizens against the third-party doctrine. Established in Katz v. United States, 1967, the third-party doctrine bypasses the Fourth Amendment warrant requirement by stating that states who have voluntarily given information to third parties have no reasonable expectation of privacy.
A proposed amendment would extend Fourth Amendment warrant requirements to government officials trying to obtain information collected by third parties.
Through debates surrounding the role of government, citizenship, and representation, the framers established a system of government to resolve the issues of their constituents. Thank you.
Okay, thank you. John, would you like to go first?
Sure. I think one of the key components of your argument is that the major problem with the Constitution of Conventions was that it didn't clearly define citizen. Isn't that a problem with much of the Constitution itself in the individual rights that were adopted both in the Constitution and in the Bill of Rights, such as just freedom of speech, freedom of press, freedom of religion? Is our Constitution too broadly defined, and should it be rewritten to more specifically define what those rights are? Are there disadvantages to that?
Personally, I do think that there is an issue in part by not having the rights enumerated in the Bill of Rights within the body of the Constitution. But I think the addition of the Bill of Rights, as the Anti-Federalists push so heavily for, solved the issue of not having explicit rights protected in the Constitution. Though there are rights seen under Article 1, Section 9, Clauses 2, 3, and 8, I don't believe it's enough. But to rewrite the entire Constitution, especially now that we have the Bill of Rights included, I don't believe would be necessary.
And to address your first point that you mentioned about it being too vague, if you look towards those citations towards Article 1, Section 9, Clause 8, for example, the elimination of titles of nobility, it's very clear in its stance that no title of nobility shall be granted to anybody within the United States. And you can also see that within your direct election with your elections of senators, as far as everything stated later in the Bill of Rights.
And to add on to both my colleagues, the issue of citizenship was later resolved by the addition of the 14th Amendment. And with that 14th Amendment, it also applies all of the rights in the first, especially in the First Amendment, but in the Bill of Rights and all amendments prior to the 14th to those now considered citizens.
All right. Let me get back to that. As part of my question was really, it's not so much did the Bill of Rights solve the problem of vagueness, but were the rights enumerated in the Bill of Rights, are they still too vague? Like, is freedom of speech, is that too vague? Do we need specific rights of what is speech, what is considered the press?
Personally, I think that the partial vagueness included, if you're talking specifically about the First Amendment, is, though sometimes not beneficial, I believe it is necessary, because if we as a nation start putting specific constraints on what is or isn't press, what is or isn't considered reliable speech or things like that, I believe it can lead to a lot of disagreement, a lot of problems for our country. For example, there's a very large argument right now surrounding whether or not Facebook and other larger internet companies should be considered press or not, and whether they should be subject to the same regulations under the First. But if we were to put specific limitations in the First, I do believe personally that it would suppress, whether intentionally or unintentionally, suppress the speech of some groups.
And I think a lot of those definitions that my colleague is speaking about is a lot of things that need to be left then to the Supreme Court through its ability to have the judicial review established through Marbury v. Madison. And allowing for that little bit of vagueness allows it to be a little bit more of a living document to address the needs of the people of the time.
Sue, do you have a question?
Your presentation opened with a quotation from Madison about the need for virtue in the people, and then I never heard another word about it. What function does that quotation serve in your presentation? And your proposals for amendments?
Well, when it comes down to all the systems of representation, having a lot of the founders believe that having that idea of civic virtue was establishing the best citizen that you could have for a country, the one that's going through and taking their part in understanding what's happening within the country, so they can then elect into office those who have the best, what he also mentioned in Federalist 10, those who can discern the true interests of the country.
The other curiosity I had is about your proposal for a privacy amendment, which seems to me to be at least as fraught as the vague wording in some of the other provisions of the Bill of Rights that have been interpreted to include a right to privacy. And so what does adding the actual words to the document do?
So through the judicial interpretations of Griswold v. Connecticut, we have seen that through the penumbra of the Constitution, privacy is protected in the First, Third, Fourth, and Ninth Amendment of the
Right.
in the Bill of Rights. And with that, we proposed an amendment to the third-party doctrine, which was established in Katz v. United States. And the proposal of this amendment is actually based off of one of the data privacy laws in the state of Utah. And with that bill, which is House Bill 57, citizens are protected with their information through the third parties by warrants, because the government has to get a warrant in order to access that information.
Okay, so I misunderstood your proposal. It's not a constitutional amendment embodying privacy. It's specifically a third-party doctrine, and how long does it take for a constitutional amendment to be adopted typically? The 27th, for example, took 200 years. Women's suffrage took 3 generations. What is technology going to look like in 5 years? And what are the possibilities that we can draft an amendment? I'm trying to get you to think about how you would draft what the wording would be that would still be relevant in even 5 years.
Well, I think that's one of the difficulties with privacy in America is the technology has grown so much different from where it was during the establishment of the Bill of Rights. And there's a lot of things there that the founders could have never foreseen, as far as the ability to have this public square that's accessible from almost anywhere in the world. And adding these small little citations to, the warrant requirements of the Fourth Amendment would help protect for future generations to then not have those infringements of government.
Is the amendment process the only way to change the Constitution? That's what you're proposing for all of this, is amendments. Is that the only way to get this done?
Not entirely. If you look towards Article 1, Section 5, Clause 3, the basically establishment of secrecy within Congress, that was completely overturned by Legislative Reorganization Act of 1970, which essentially allowed for the public hearings of Congress to be televised.
Also, we don't need to go specifically make a direct constitutional amendment, but allow it to fall to our judiciary and make a Supreme Court case that would set a precedent against certain encroachment. So it doesn't have to go directly to the Constitution.
And the possibility of the Supreme Court disagreeing with you, if they ruled against what you're proposing, what would that mean, or what would that look like? I mean, there's absolutely no guarantee that especially this court will be interested in expanding privacy rights of any kind. Oh. I want to hear what you think.
Oh, thank you so much. It's feedback time. John, would you like to go first?
Let me begin by saying I thought this was your arguments were excuse me. It's getting late here on the East Coast. Your arguments were well reasoned. It was entertaining. It provoked a lot of conversation with us. One thing I will say is my question was kind of thrown to you to sort of highlight one of the reasons why the broad rights in the Constitution are worded so vaguely and open-endedly is that the Constitution then gives the power to Congress to enact specific laws to address those rights. That's why with your third-party privacy, probably that is something that's more in the line of Congress to enact the law limiting the warrant powers of information granted to third parties.
Thank you. Sue?
Well, nice presentation, very engaging. And you highlighted the point of citizenship being unresolved by the convention. You're the first team to do that today, believe it or not. And that's core, and they couldn't define citizenship because of slavery. Proportional representation led to the need for the 3/5 compromise because of slavery. So the whole slavery piece is almost the elephant in the room, but tying in the citizenship piece I thought was really good. Making the Electoral College more representative of what? It's true in your state as it is in mine. The real divide is urban rural. And if we go with more representation, it means Seattle and Portland get to dictate what goes on in our two states, and the heck with the rest of it. So I would like you to push a little harder on what it means, who and what deserves representation. And I think that's going to be the critical issue for the next generation. This urban rural mess has got to be resolved somehow, or we could be headed towards a very unsavory breakup of the union. Anyway, nice presentation. Really appreciate your hard efforts.
Thank you. I think, I agree with it was provoking, it was passionate, very 100% clearly articulate, followed through. I know where you answered each of the components of the question. I do, you say slavery was solved. Not quite sure it was 100% solved at the time. But I did really I got excited when you talked about citizenship and citizen, defining a citizen, and then kind of doing that through line of the 13th Amendment. Oh, but wait, then there were Jim Crow laws, and just kind of thinking through that. I would like to see that type of thinking when you propose that you're going to make amendments, because then you're already thinking about what worst case scenario is. So how do you manage around that and think through that when you're talking about both the Electoral College and privacy? I also would have liked, I feel like we went right from citizen, defining a citizen, 13th Amendment, then we jumped right to Electoral College and privacy. And there wasn't a through line. You were really focusing on that citizenship piece and citizen, just a little bit clearer in terms of communicating that through line about what in the Constitution needed to change, maybe in relationship to that concept of citizen. And your follow-ups, right? You know your Constitution, and you were able to bring up examples. Each one of you was able to bring up different types of examples that were outside of what you brought up in your opening statement. That was good. The third-party doctrine, HB 57, all the different, and we went into judicial review. So there was some really good still unpacking of those constitutional principles in the follow-up, which is difficult. And the other piece is, the Supreme Court doesn't make cases. That. It takes time for them to get to the Supreme Court. That's how they make the decisions, and that's part of the process as well. So I think it was really powerful. It was thank you for ending my day like this. It was a great conversation, and good luck.
Indeed.
you.
Thank you so
Take
much.
care.
Thank you.
Thank you so much, students.